Good afternoon. This is Attorney Elise Gross bringing you today's webinar on estate planning and digital assets. Thank you very much for joining us today. Before we get started, if you're not already receiving our weekly e-newsletter, please let us know at info@assetprotectionattorneys.com. If during the course of the webinar you have any questions, please either email them to that email, info@assetprotectionattorneys.com, or type them in the chat box. If it's something that I can answer quickly without losing too much stride during the webinar, I'll be happy to answer it through the chat box or address your question verbally. If not, we will send you a follow-up email. In addition to our weekly newsletter, we offer complimentary preliminary consultations with regard to estate planning and asset protection issues. Feel free to contact the firm and set that up if it's something that would be useful to you. If you have a group that would like to have a private speech with regard to estate planning or asset protection, please let us know because we could potentially set that up as well. I've been an attorney in South Florida for more than 25 years, and my firm practices in the asset protection and estate planning arena. I've also been an adjunct professor at Florida Atlantic University for the last almost 10 years, where I teach paralegals with regard to estate planning. Today's webinar addresses a very interesting and kind of new topic, and that's digital assets. So when I first became an estate planner over 25 years ago, digital assets really didn't exist. And to what a digital asset really is, we'll talk about in a moment, but it's really become a very evolving topic. And it reaches not only into estate planning, it reaches into asset protection, it's in litigation. Really, it's become part of every type of law. So what I wanted to do today is just address the concept of what are digital assets, how should we address them moving forward during your estate planning process, and what can we do to make sure that we're protecting them so that if there's any monetary value to them, they're passed on. If it's emotional and non-monetary value, that somebody has access to the data. And we're going to talk about a little bit about what the current laws are. And again, they are ever evolving. So, the laws are going to continue to change. So what would be a digital asset? Well, it would be things like your domain names, your websites, your emails, all of your different email accounts, the data that's within those things, the content of your websites, all of your photos that you keep digitally somewhere, blogs and vlogs that you've done, YouTube videos, any sort of social media, Facebook, Instagram, Snapchat, your bank accounts, your credit cards, your mortgage information, your rewards cards for any stores, for travel, for your credit cards, any of your credit card from, your store credit cards, anything of that nature. And lastly, the most interesting and really kind of the newest concept is cryptocurrency. That form of monetary value that nobody really, I don't think, understands very well, but has become a big part of how business is done and how people are using money nowadays. And I think it's going to be a lot bigger. So we're going to address that as well. So you have these digital assets, and the question becomes, what do you do with them? How do you handle it? So the first thing you need to do is you need to determine what are your digital assets. We just went through that whole long list of what digital assets can encompass, but that's not going to be the same for everyone. So the best thing to do is when you're addressing this situation is just like with anything else, just like with any other assets, is to sit down and make a list or an inventory. And what you do is you write down all of your websites. You write down, do you have a YouTube channel? What social media are you on? And any place where you might have stored information. Do you have an online storage portal like Mozy or, well, not Mozy anymore, I forgot what it's called now, but there's online storage portals where you do cloud backup. Do you have a digital safe deposit box for your documents and your data? So many people have different portals that they can log on to. A lot of financial advising companies will offer you portals, and then there's others that you can subscribe to yourself where you can store your bank account information, your mortgage information, your wills and trusts, your powers of attorney, your contracts, your stock certificates. Anything that relates to your assets can potentially be stored in one location, which makes things a lot easier for your professionals to be able to access the data. It's kind of like a Dropbox, but it's more detailed. It's usually meant for not just documents themselves, but it's meant to integrate with your bank accounts and with your mortgage companies so that it'll do real-time updating when you pay a bill. If you pay your mortgage, it'll reduce your principal balance and show up to the minute. If you log on, you can see where you stand from all facets. Unlike with a Dropbox where, it's just a data storage, document storage portal. But even Dropbox, that's one of the things that we would need to list on our digital asset inventory, because your Dropbox account could contain many pieces of information that somebody may need later on. And just a little bit, going a little backwards on estate planning is not just what happens after you pass, it's also what happens while you're alive and potentially incapacitated. So we're not just talking about your trustees under your trust or your executor or personal representative under your will. We're also talking about other fiduciaries like your agent under your power of attorney, or even under certain circumstances, your healthcare surrogate under your healthcare surrogate form. So we're going to address all fiduciaries when we're talking about how they're going to need access to this information. So the first thing we do is determine what are actually the digital assets that are involved, and we create that list. Once we have the list and have identified all the digital assets, then we have to put in the important information, the account numbers and the passwords, usernames, answers to security questions, anything else that might be relevant for somebody to be able to access that information. The other thing you would want is, and we'll address this a little bit later, but you would also want to have a copy of your terms of service agreement, if there is any, with the digital asset provider. So for instance, do you have a terms of service agreement with Google for your Gmail account, or with Facebook or Instagram or Snapchat or any of those others, Skype, whatever it is? If you have a copy of that terms of service, then you might as well upload it somewhere and give somebody access to it. And we're going to talk about why in a little bit. Now, you're probably asking yourself, okay, great, I'm going to write this list down. And you're probably cringing because you're thinking, well, in today's day and age where there's so much identity theft, do I really want to have a list with all this data on it, which somebody could use against me? And the answer is, you probably do want to have it. However, you have to balance out your concerns about privacy and safety versus the upside, which is that somebody would be able to access this information after your death or incapacity when they really need it. So there's really no good answer with, where you should put this list, but you really need to have it. And there are a lot of different options out there for secure portals for this and secure apps, I would encourage you to do some significant research and really look into it as to where you should be storing this information. But the truth of the matter is, not storing the information will probably be more detrimental to you after your death than storing the information. So if you can find some sort of happy medium where there's a safe enough place to store it, where you can continually update it without too much drama, that somebody else can access that information when it's needed, then I would certainly recommend it. Okay, so how do you access the information? Well, the way to access it is if you do have all of that information somewhere, whether it's in a digital portal, whether it's online, whether it's a physical piece of paper, which, believe it or not, most people find to be the most secure, to actually physically write it down and not put it in their computer. Some people don't even type it. Some people just literally by hand write it all out. The good news with that is that the only time somebody can actually get at it is if they know where you keep it and access that. The bad news is that it's not as easy to update that list, because if you have to cross out, put in a new password, it just becomes extremely messy and a little bit difficult. So if you are going to do it by hand, then what I suggest is the first thing you do is you make out that inventory list. You add in all the pertinent information and print out, not the information, but print out some sort of spreadsheet that you can fill out so that if you do need to change anything, it's very neat, and all you need to do is, use some whiteout and take out the information and put in the new one, and maybe put a date next to it so we know when you last updated it. So that might be the safest bet, and just keep that in a very secure location. But again, it's not going to be accessible by somebody on your computer later on, and it may not be the neatest form of putting this information all together. It's a personal choice. I've seen people do it both ways. It doesn't really matter how you choose to do it, as long as you do it and you keep it updated. Then what you do is you go see your estate planning attorney and you incorporate some powers into your estate planning so that you do have somebody, we'll call them a fiduciary, whether it's your agent in your power of attorney, your successor trustees, or your personal representatives through your will, that have specific access to all of this data, to all of the websites, to all of the social media, to all of your bank accounts. They need not only the information to get in, i.e. passwords, usernames, and security questions, they also need your authority, because without your authority, then they could be committing a crime and it could be a major issue. So what you need to do is take the responsibility as part of your estate planning and incorporate fiduciaries. So of course you would be naming fiduciaries anyway. So you want to make sure you name your agent, your trustees, and your personal representatives. Name as many backups as you feel comfortable naming. We call them successors. And then in the documents itself, you want to specifically give those fiduciaries access to the information and to be able to recover and change passwords. Because if they're not specifically authorized, then even if they have the means to get in, they're technically doing something wrong. In addition to that, because that's only one part of the problem, is giving them the power to access. The second part is you have to actually distribute those assets. Now, the good news is if your will and your trust are non-specific as to assets and just have general provisions like about the residuary or all property in the trust, then you don't necessarily have to address those digital assets directly. But maybe you do want to address them. Maybe you want those digital photos to go to somebody specific. So you need to address that in the document and say that. Maybe you only want one person to have access to your social media accounts or your bank accounts, and you don't want all your named fiduciaries. So you need to be specific as to that. The key is specificity, and the key is making sure that you understand that there is a possibility to have digital assets, and that if you don't address it, you could be creating problems later on for your family or whoever is taking over after your death to take care of whatever they need to take care of. So cryptocurrency is a very new type of currency. And essentially what it is it's kind of like phantom money. It's kind of like play money almost, but it's real. So it would be like if you took Monopoly money and went to a store. That's the way a lot of people think about it. It's just, they think of it as fake money. But as the concept develops and more providers are coming about and dealing in this electronic currency, we're going to be seeing a lot more of it. So because we're going to be seeing a lot more of it, there will be ever-changing laws to address it, because obviously there's going to be a lot of problems with this. There's going to be a lot of litigation about it. Does it really exist? Who really has access to it? Is it really your money? Is it really legitimate money? Can you really pay for things via cryptocurrency? All that stuff's going to be evolving over time. And it's going to take a while for it to really take a stronghold and become maybe not a primary source of payment, but it's coming close. And what are the predecessors to that? PayPal is a predecessor to it. Any type of, the Zelle and the Venmo, that was our first really experience with transferring money and dealing with, non-paper money and non-checks. So we've moved into this arena. We've now made it even more interesting by creating this electronic currency, which is basically where you have a code or a private key, and that private key is some sort of numbers and or characters that identify your money, that identify your account. So whether it's Bitcoin or some other source, you're going to have some sort of key to identify it. Without that key, it doesn't even exist. No one will have any idea that it even exists and that money is there. So if you want to be able to make sure that your family after your death is able to access this cryptocurrency, they absolutely have to have all the information necessary to address it and to access it. So there's a unique electronic address, there's a private key. Somewhere, somehow, somebody needs to be able to get an idea of how much you actually have of this cryptocurrency. So what do? Well, the private key is, again, the only way to be able to access this money. It's kind of the newest version of the bearer bond, where the bearer bond was whoever held the piece of paper was the owner of it, and you could transfer it from person to person by them literally being the one holding it in their hands. Cryptocurrency is the same thing. If you have that data, if you have that private key, if I stole it from you, it's mine, and good luck to you figuring it, being able to prove that it was yours. So that private key is pivotal information, but extremely dangerous information in the wrong hands. So there have been suggestions to actually splitting up the private key into different locations. So maybe you give half the private key to one person and half the private key to the other person. So without the two of them, they wouldn't be able to access the information. It's a little bit old school, but it could work. And obviously those two people, you don't want those two people communicating about the key beforehand, but you want to make sure that they know or you've written it down somewhere that here's how this information can be accessed. We need persons A and B to get together and put together the whole private key. It's a methodology. I'm not sure if it's a little too over the top, but the cryptocurrency can be dangerous if it's in the wrong hands because somebody else can claim it. So you do have to be very careful. Cryptocurrency is often called the black hole wallet because nobody really understands it at this point, or not too many people. And what's in there is kind of phantom until it's actually used. And you're going to see time, people are going to be paying more and more with cryptocurrency. I don't think we're quite there yet. It's pretty limited at this point, but I do foresee that you're going to see a lot more of it coming in the future. So again, with the cryptocurrency, you're going to have excellent records, and you're going to have to protect the data of how to access that money. What I would do is, if I were somebody who owned cryptocurrency, I would put in my estate planning documents specifically that there are assets that are in the form of cryptocurrency, that the key to get into the money has been carefully distributed to certain individuals, and maybe name those individuals. And that way your personal representative, who may or may not be one of those individuals, or your trustee after your death, know where they have to go to access that information. And I don't know that I would list those cryptocurrency keys on the same list that I'm listing all my other digital assets, because maybe you kind of want to split that up. It's a personal decision. So what's our next area that we need to discuss? So we've already identified what our digital assets are. We've made our list of it. We've put down all the information that we have in order to give somebody access to it. We've put it in our estate planning documents that we've empowered fiduciaries to specifically deal with the digital assets, to be able to access the accounts, to be able to change passwords, to be able to recover passwords if they don't have it. We've put down on that list what email address we used for that account, because most of us have multiple emails. And if we're using multiple email addresses for different accounts, then you do need to put that down as well. Not just the username, the password, the security questions, but what email actually gets you there. And then, of course, on that list is going to be the different emails. How do you get into the different emails? So it's a process, and somebody is going to have quite the chore later on to have to deal with all this stuff. But if you give them the tools, it's going to make life a lot easier. If you don't give them the tools and somehow they manage to access it, so for instance, if they have the code to get on your computer, or maybe you don't have a password to get on your computer, or it automatically allows you to get on the computer, they can probably get into a lot of your accounts, because if you've saved your passwords on the computer and they just click from your computer, they're probably able to get on, which is good in one sense, but bad in another, because what they may be doing is violating a law. If the term of service agreement states that somebody else is unable to access your information, and if somebody accesses that information, that could be, an illegal act. Or if the only way you can get on is by getting somebody to hack into the machine, your goal might be a noble goal because you're the fiduciary and you need to get the data in order to make sure that the estate is distributed. But just because that's your goal doesn't mean that you really had legal access to the information. And there's different federal laws and then there's different state laws, and I'm going to go into on the next slide what the main law is on this. But understand that different states might have different laws, and you've still got the federal laws that you have to follow. So you need to have authorized access. And authorized access is from having the information available to you, being empowered under the estate planning documents, and then knowing what the terms of service agreement says so that you're not violating in terms of service agreement. But what are really the biggest issues? Your goal is to have somebody get the information so that they can deal with everything at your death. You want, while you're alive, you want everything to be as private as possible, and you also do not want to have anybody else's privacy violated. So when your fiduciary is taking on this role after your death or incapacity, they have to be very careful that they're maintaining your privacy, because privacy does survive death. They have to maintain your privacy and the privacy of anyone else involved. That's a big issue if, for instance, you have a business or business emails or business data. If any of that information is meant to be confidential, then you run a big risk with having a fiduciary being able to access that information. That fiduciary may not have been under the same confidentiality agreement. The good news is if a confidentiality agreement is drawn up properly, then it does continue for your heirs and your fiduciaries, and you as the fiduciary know you're bound to it. So you have to maintain the confidentiality. Now, I'm in a profession, I'm a lawyer, and this is going to come up. So when I die, what happens to all my files? What happens to all of my information on my computer about my clients? So I'm very careful. I keep very little on my computer about my clients. Kind of old school. I like to have regular files, not digital files. So I don't have that much on my computer that somebody could access. But you need to know, if you're a professional, whether you're a doctor or a lawyer or a CPA or anyone who has confidential information at their disposal, you have to know what the rules are in your business to make sure that confidentiality is maintained even after you pass. So we have here, I have the state bar. They give the parameters for what happens if somebody passes away who has access to the confidential information. What do you do? So as an attorney, I have to plan for that, as should any other professional that has the access to confidential information for a client or a patient or, a business associate or whatever it is. We have the responsibility ourselves, and therefore our fiduciaries are going to have the responsibility too. So you may have to make sure that you have some sort of plan in place and that you've actually gotten that information from whatever governing body governs your profession. So again, for the lawyers, it's the bar. For the CPAs and for the doctors, they have their own governing board. So you need to be apprised of that, and you need to give very specific instructions to whoever comes after you, to whoever your fiduciary is, because they probably won't know. And if you don't provide that information, they may do something wrong, and then your estate can be sued or your fiduciary can be personally liable if they make a mistake. In addition, the main issues that we have with accessing information are obviously privacy, people hacking into your computer, fraud, if they do it, if they're hacking in and they do things illegally. Because remember, hacking has it can have a very strong negative meaning, but it's also commonly used if somebody has to gain access to a computer that they don't have the tools to gain access to, they don't have your password, and they have to override and find some way to get in because they need that information. That's also called hacking. So you have to be careful. Is it illegal hacking, or is it just having tools somewhere to access the information, or being empowered to access the information, but somebody fails to give you all the tools that are necessary? So you need to understand what the different meanings are and what you're actually doing to make sure that you're not doing anything illegal. So we've talked about the legal issues. We've talked about what digital assets are. Now let's talk about what the current law is with regard to digital assets and protection. So the first thing I said when we first started is this is an ever-evolving field. there is not that much raw data here, and every day new information is coming about and new laws are being developed to address new problems that we didn't know existed because this is a new area. And that's what happens with any new area of law. So we have to assume that what exists today as the law is likely to be amended many times over, and then will ultimately settle until on occasion it'll have an amendment if something new comes up or they need to update something. But it's going to be a while before you really have solid law that addresses all of these issues. But for right now, what we have is the Revised Uniform Fiduciary Access to Digital Assets Act. It's kind of a mouthful, RUFADA. It was preceded by the same thing without the R. It was just the Uniform Fiduciary Access to Digital Assets Act. The good news is the majority of the states, 41 or more, have adopted it. So it was pretty quick to get adopted because all the states knew that they needed to address this situation. So what happens is that the original creator of the information can give an affirmative consent to disclose the electronic communications or any of this data, and then that consent is going to override terms of service agreements. So if you put in your documents that you're consenting to the affirmative disclosure of the communications, then you've just complied with RUFADA. Now, if you don't include it in your estate planning documents, depending on what state you're in, it might still be okay because the law itself, that act, kind of allows an override, but you don't want to rely upon that. You need to make sure that you cover all bases by putting in the consents necessary because you don't know what the laws are going to be. You don't know how it's going to change or what's going to be in play at the time. So you want to make sure, in a recap, that you name your fiduciaries, that you name them carefully as people that you can trust, that you specifically in your estate planning documents give access to the information and to allow for retrieval of passwords and changing passwords because they'll want to change it after your death. You want to make sure that you've covered any issues of confidentiality if they're specific to your industry or even just in general, so that you've given specific instructions to your fiduciaries how they should address those issues because most people wouldn't really know what they're supposed to do. You want to make sure that you have a very detailed, extremely current list, an inventory of your digital assets and all pieces of information needed to access them. And you want to make sure that list is kept in a very safe place, whether it's a paper list, whether it's a digital list, whether you split it up, however you want to do it, that you feel some degree of safety. I don't think there's anyone who makes such a list who's ever going to feel 100% confident of the safety of the list, but you should at least do whatever you need to give yourself some confidence in the safety of the list. Somebody might say they're going to keep it in a safety deposit box or in a home safe. The problem you have with the safe deposit box is that when you die, if somebody is not on that box with you, no one will be able to get into the box. Therefore, they're going to have to get a court order to get into the box, and then they're going to inventory every asset in the box, and you may not even be able to get the list out. So I wouldn't recommend that. You can put it in a home safe, but you have to make sure that the most trusted person in your life has a way to access that safe if need be so they can get at that information. You could put it on a flash drive and the same safety measures, put it in your home safe or somewhere that you feel confident in your home. But that's going to mean you actually did the work on your computer. And as most of us know, most of that information is never lost, even if it's erased. So that has a little bit of a scare to it. because you will have typed it on your computer. Obviously, if you typed it, it's going to be a much neater list and much easier to edit. But again, it's a personal decision, and I don't think there's any right or wrong answer with regard to addressing this situation. So that's what we have for today. I just wanted to just go into that a little bit and open you up to the idea of digital assets so that you can address it with your estate planner, and you can start thinking about how you're personally going to deal with your digital assets. Having prepared for this webinar, it actually inspired me. I'm going to go home and make that inventory because I really don't have an up-to-date one either. And obviously I have to figure out where to keep that safe, but I'm not going to tell everybody where it is because that would really defeat the purpose. So I want to thank everybody for joining us today. If you have any questions, feel free to email them in and we will address them. We'll send you emails back. If you want to get our newsletter and you're not already receiving it, just send us an email to info@assetprotectionattorneys.com. And if you want to set up a complimentary preliminary consultation, or if you're interested in having one of our qualified speakers come speak to your group, we'd be happy to do so. Thank you again for joining us today.